Welcome everybody to Insight's CPRA Readiness webinar. I'm going to introduce our two speakers today. We have Jeff Edwards, who's the content lead at Insight. He'll be leading the discussion here today. And on deck, we got Jason Patel, the CTO, who's going to provide context and give his insight from his years in helping keep companies and organizations secure and in compliance with privacy law. And with that, I'm going to pass it over to Jeff.
All right, thanks so much, Chris. Welcome, everyone. We're going to be going over the CPRA today, which is California's newest iteration of its privacy law. To start things off, though, I am going to just quickly review the CCPA. I know that most people in attendance today are probably familiar with the CCPA, but we want to give you a baseline in case you've forgotten the background of California's privacy laws. So the CCPA was the first comprehensive privacy law passed in the United States. It was passed in 2018, just after the GDPR, and went into effect in 2020. And that law gave California residents a few rights, not going as far as the GDPR, but a lot more than most states in the US, and even more than subsequent privacy laws in the US. Gave California residents the right to opt out of having their data sold to third parties, and the right to request the disclosure of the data that had been collected, as well as the right to access their personal data, and that would be the data subject access requests that marketers know and love, as well as the right to request the deletion of any data that has been collected erroneously. Failure to comply with those directives could result in fines of up to $7,500 per violation or $750 per affected user, which doesn't sound like a lot, but adds up quite a lot when you have a spreadsheet of 2,000 or 3,000 contacts. So the CPRA is affectionately known as CCPA 2.0 by a lot of people. It is essentially the next step in the California privacy regulations. What it does is amend and expand upon the CCPA without explicitly replacing it. Essentially, the CCPA set out a baseline for California privacy law, and CPRA is building it out further. You can kind of envision it as being halfway between the CCPA and the GDPR in terms of its effect and its weight. It does have some teeth. It's got a lot more rules than the CCPA, and we're going to get into that here. Just to sum up the changes made, what it does is it codifies the data retention requirements regarding personal information. It modifies the definition of personal data and introduces a new category of specially protected personal data. And it alters the definition of the businesses that comply, so the scope of the law. It gives a few new rights to employees as well as consumers and business-to-business contacts. It creates an enforcement agency that will be responsible for enforcing California privacy law as well as coming up with new rulemaking. And it brings into reality the private right of action that was set forth in the CCPA, and makes that a broader use case for the private right of action, which we will cover a bit later. It does go into effect on January 1st, 2023, with rules and enforcement actually beginning in July 1st, 2023. But there are some requirements that can be applied retroactively. There is what's called a look-back period to January 1st of 2022, and that is primarily related to the privacy assessment piece of the law, which we will cover towards the end of our presentation. There are some key regulations that have yet to be defined for the CPRA. So there are going to be some questions that, unfortunately, we don't have the answer to, as the regulators have not made that decision. They're in the process. They are supposed to submit the final regulations by the end of this month, but it's not looking that way right now. So we may have to keep an eye out for new things. So this is just a brief overview of the differences between the CCPA, the CPRA, and the GDPR. And you can kind of see here how it slots in as the middle ground between the two laws and the way that privacy regulations are trending in California. And, you know, it's not on the same scale across the nation, but across the whole nation as well. They are trending towards stricter requirements. So we did have the right to access, the right to deletion, and the right to data portability under the CCPA. But now there's the addition of the right to correction, the right to opt out of data sharing, not just selling as under the CCPA, that has been expanded to buy-side advertising, and the right against automated decision-making and profiling. So that would be like machine AI decision making and profiling. That's actually in the works right now. They've essentially laid out that they would like to give people the option to opt out of automated decision making, or at least access the information being used in that decision making. But the enforcement body set forth by the CPRA has not come up with a decision on that just yet. Finally, you can see where it kind of falls short of the GDPR would be that the CPRA is still an opt-out consent model, meaning the onus is on the consumer to go in and tell you that you don't want to be tracked. I will say that as far as opt-out consent models go, it is probably the strictest one we've seen so far, and we'll get into that a little later. So here are a couple more of the changes. Just going to touch on some ones that we're not going to touch on elsewhere. So we will go over the consumer privacy rights. As far as obligations for businesses, most of that has to do with your privacy notice and notifying at the point of collection things like data retention periods, why you're collecting certain data, what third parties and contractors you're working with, and what they are doing with the data. It's very similar to what you would have to do in a privacy notice under GDPR. So if you're compliant with GDPR, or if you have a GDPR ready privacy notice, that will work under CCPA. There are a couple differences that we will get into. Again, the private right of action is a consideration now, and as well as expanded new definitions for consent and SPI, which we will get into. Consent has changed quite a bit. They've got some pretty specific consent requirements for your links and then for your consent banners as well. And then we will cover risk assessment, cybersecurity audits, the enforcement body, as well as data retention and minimization limits. One thing we're not going to talk about elsewhere, so I'll talk on it now. The exemption for employee and B2B data is expiring on January 1st when the CPRA comes into effect. And what that means is where previously the CCPA was really focused on consumer data only, so like more for B2C businesses, now your sales lists, your marketing lists, MQLs, SQLs, whatever, that is all under the purview of the CPRA. So it's important to keep that compliant. We'll talk about that a little bit. So are you regulated by the CPRA? If you're in this webinar, I'm guessing probably you have some skin in the game, but we'll just go over it really quickly. The CPRA's requirements are basically the same as the CCPA, although they have changed certain things. They've actually upped the amount of consumers or households whose information you need to process from 50,000 to 100,000, but now that it includes employees and B2B contacts, that number is a lot easier to hit. So if your company's revenue exceeds $25 million and shares or sells personal information of California consumers, you are regulated by CPRA, a lot of acronyms. If your company buys, sells, or shares the personal information of 100,000 or more California residents, you are covered by CPRA. If you derive at least 50% of your annual revenue from the selling or sharing of the data of California citizens, you are covered. And those are not mutually exclusive. If any one of these, you're covered. You don't have to have all three. How will the CPRA be enforced? So there is kind of a first of its kind enforcement body being created in California. It's actually in act now. That is called the California Privacy Protection Agency, or the CPPA. That is governed by a 5-member board, mostly privacy lawyers, but they've got a lot more employees than that. They're actually hiring a chief auditing officer to audit businesses for cybersecurity violations. They are responsible for enforcing the law. They're responsible for coming up with new rules. They're responsible for clarifying regulations. So they have rulemaking authority as well as enforcement authority. The funding for the CCPA is $10 million a year. But interestingly, administrative fines that are taken in by the agency will go back into funding the agency. So the more fines they hand out, the more they're funding their own agency. So it could potentially have a snowball effect. I can't really speculate, but we know when there's a police department who gets funding from traffic violations, they tend to write more tickets. So that's something to keep in mind, that this regulation does have some teeth. Marketers in particular have a tendency to like to sit back and wait on things like this. This is one where I would say try to get your ducks in order as soon as possible, you don't really want to have the hammer come down on you. There is also a private right of action. Now, there was a private right of action before under the CCPA, but it was very limited in what it could be used to. What a private right of action means is citizens can bring civil suits against companies for mistreating their data. And now under the CPRA, that applies to things like a username and password combination, an email address and password, or a security question and answer. So if any of those things are unlawfully accessed, that is reason for a lawsuit. And you might think, we don't tend to lose usernames and passwords, but you'd be surprised the amount of unencrypted, open, Google Docs or Google Sheets are out there on the internet with passwords and usernames in them. So that's definitely something to look into. You don't want to be on the receiving end of one of these class action lawsuits. So let's gonna start off with the right to correction, which is the first of the 3 new rights under the CPRA. This is a pretty simple one. It doesn't have a huge impact on marketers, but it can definitely create a lot of busy work on the back end. Under the right to correction, a consumer shall have the right to request that a business that maintains inaccurate personal information about them has to correct that information, taking into account the nature of the personal information and the purposes of the processing of the information. The consumer's right to correction has to be included in your privacy statement, along with the other rights that they have. And as for operational impact, what this essentially means is that while keeping complete and accurate data for a marketer was once a best practice, now that accuracy is a legal requirement. So, for example, there are some organizations that are still taking incomplete contacts and building them out with purchased or supplemental third-party data, maybe Zoom info lists or something like that. In that case, you're really going to want to make sure that any information you're pulling in is accurate and that it has legal provenance, that it's been legally obtained. Data retention and minimization under the CPRA. If you're familiar with the rules of the GDPR, this is going to be really familiar to you. The business's collection, use, retention, and sharing of a consumer's personal information shall be reasonably necessary and proportionate to achieve the purposes for which the personal information was collected or processed, or for any other disclosed process that is compatible with the context in which the personal information was collected. And it cannot be further processed in a manner that is incompatible with these purposes. So that means what you put forth in your privacy statement, what you put forth at a point of collection, that is essentially the limitation of what you can use the data for. Now, alongside that, you have to put forth the amount of time that you're going to be keeping this data, as well as your reasons for the timeframes that you're keeping it. This means we need to be more strategic in what information is being collected and stored and for how long. Operationally, users now have the right to know the business intends to know the length of time to retain each category and why. The business must also be able to provide the criteria used in determining those timeframes, and the data can only be retained and used in a manner compliant with all of this, as I said. Automated decision and profiling, like I said, this one is a little bit up in the air. The CCPA or the CPPA, sorry, these acronyms can get a little much, is charged with issuing the ruling on this. So far, they haven't put forth much. All we really know is that they want to regulate it. They haven't decided yet what mechanism via which a user could opt out of automating processing, or what is the manner in which they could access the information being processed. The only thing they have defined in the letter of the law is their definition of profiling, which means any form of automated processing of personal information to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning that person's performance at work, economic situation, health, personal preferences, etc., essentially PII, using machine learning to bring forth PII about a person. So this is where it really gets interesting. This is the new category of sensitive personal information set forth by the CPRA, and that has special protections under the CPRA. The CCPA set forth definitions for personal information prior, and that was your typical PII stuff. This CPRA sets forth this SPI. And what that is a category that includes information like your social security number, your driver's license, your precise geolocation as opposed to your general geolocation, which is covered under the CCPA, things that are protected status like race, religion, sex, sexuality, your finances, your communications, your passwords, and then your protected health information. Californians under the CPRA do have the right to limit the use of SPI. There is an approved list of use for SPI, and that would be what's necessary to perform requested services as would be expected by a consumer, using it for security or integrity purposes, data integrity purposes. If you're using it short-term and transient use and it is deleted immediately after, it's used for account services, so if it's part of like a healthcare account or a banking account, or if it's used to verify and maintain the security or quality of service or device. So that would be something like verifying your identity with your driver's license number or your social security number, something like that. If it's used for any other purpose beyond that, businesses under the CPRA must provide a link for consumers to limit the use of that SPI, wherein they can opt out of the use of it. A business cannot use a customer's SPI for any purpose once they have opted out, unless consent is once again granted. That's a little bit different than opting out of data sharing, which we'll see in the next slide. So you have also the right to opt out of data sharing, not just data selling under the CPRA. So sharing under the CPRA is a consumer having the right to, at any time, direct a business that sells or shares personal information about the consumer to third parties and contractors, not to sell or share that information. And when they say sharing, they mean communicating by any means that personal information, whether for monetary value or other value or not. So that includes sharing via a Google Pixel or a tag or a Facebook Pixel or whatever. That is all covered by this. It's not only the selling of data, it's what they call cross-context behavioral advertising. And that would be advertising targeted based on personal information obtained across businesses, websites, applications, or services. Essentially, this extends opt-out rights to buy-side advertising writ large. So this is a huge deal for marketers in working with California citizens. And we're going to cover next the updated consent requirements for gathering the opt-out or the opt-back in. So the definition of consent has been updated under the CPRA. It now includes a stricter definition that is very similar to that found in the GDPR, and that consent must be specific, freely given, informed, and unambiguous. And what that means is that consent does not include general or broad acceptance of terms. So for example, if I bought a new iPhone today and accepted the device terms, in doing that, they can't say, okay, you've also accepted our ability to go ahead and share your data. That does not count as consent. It doesn't include things that you would call dark patterns either, which would be like quickly clicking away from a consent banner or navigating past the menu or coming into the website through a different manner. Things like that do not count as consent either. And when you're looking at this, it is an opt-out consent model. So again, the onus is on the user to opt out of having their data shared. But when I see these stipulations put forth on consent, what I see is a possibility this is laying the groundwork for an opt-in consent model. Minors already under California law do have an opt-in consent model. If business has actual knowledge that the consumer is less than 16 years old, they are required to get affirmative authorization from that person before they can be tracked. If they have actual knowledge that the user is less than 13 years old, they need affirmative authorization from the user's parents in that case. As far as what the opt-out needs to look like, businesses need to present clear and conspicuous links on their homepage for opting out of data share and sales, and for limiting the use of your sensitive personalization. You have to have both links present on your homepage. They need to be readily visible. It is possible to combine. It is legal under the CPRA to combine them both into one link, as long as clear and conspicuous. As far as tracking after an opt-out goes, the rule to the letter of the law is that once a business has received direction from a consumer not to sell or share the consumer's personal information, or in the case of minor consumers, they haven't received consent yet, they shall be prohibited from selling or sharing the consumer's personal information after the receipt of that direction at any point. Now, that's a little bit different than the CCPA, where there was a heal period where the businesses had 30 days to correct. We kind of breezed by that earlier, but that has been repealed. And I think we cover that on the next slide as well. So for consumers who exercise their right to opt out, it is not possible to continue badgering them for consent under the CPRA. You actually have to keep on file that they've opted out for a year before you can ask them to opt in for tracking again. And Jason, I actually wanted to bring you in here because one of the issues that we commonly see when we're doing compliance evaluations and helping build out compliant consent systems is businesses failing to stop tracking signals after an opt-out, especially in the case of EU websites too, where it's required before opt-in. Can you talk about why this issue is so prevalent and what can be done to address it?
Yeah, absolutely. So this has been a problem since the birth of any privacy law that's emerged, whether it be GDPR, CCPA, CCPR, or CPRA. But effectively, a lot of the language initially for any of these privacy laws always talked about cookies. And so, a lot of marketers and anyone else just kind of threw a cookie banner up on the site. They assumed that any technology running on the site would just respect any preference settings that was dropped by the cookie banner, and it was kind of like a hope and pray mentality, right? Where it's like, man, I hope Blue Kai or Crux or whatever else I'm using respects my end user's preferences by reading that cookie on site and not actually collecting their data. Unfortunately, though, that's not really the case, right? So then if you take a step forward, how do you actually address this problem, right? So that's where solutions like Insighten or any other thing in the market comes in, where you have a couple different options, right? There are some solutions that push for an IT heavy workflow, right? Where either you have to change how your site is built, or you have to modify your workflows where you have to train your staff on privacy laws. You have to make sure that as they're tagging the site that they're going to need to make sure to categorize these technologies correctly and then link them up to the correct consent manager that you have running on site. So hopefully your end user preferences are respected. And that still leaves gaps, right? Because in these types of solutions, there's no real audit trail about what's been blocked, why it was blocked, when this consent event happened, stuff like that. And then you have more solutions like Insighten, where we kind of operate transparently in the mix, where we'll help figure out what's running on your site, categorize it, and then suppress whatever is opted out of, or unsuppressed in the GDPR case of whatever's opted into. And that way, you can maintain logs, you can actually get some auditability around what's going around your privacy configuration while letting your marketing teams operate unhindered, right? Because, effectively for the last decade, we worked on trying to gain marketers a lot of agility as technology became more prevalent in their day-to-day jobs. The goal should not be to put friction in that process now, but look for pathways where we can conform to this new legislation, but also keep marketers doing their job.
Yeah, awesome. Well said. Couple more things just to touch on as far as consent goes. CPRA has given guidance, or I should say the CPPA has given guidance that opt-out preference signals sent, so in an HTTP header field or something like that, are considered valid consumer privacy requests, so they must be adhered to. In that case, you do not have to serve the consumer the opt-out links. You just have to follow that preference signal. There hasn't been any technical guidance on what constitutes a preference signal and which ones are valid and which ones may not be yet. So we can look for that in the coming months. And then on June 7th, actually, the CPPA released some draft regulation language, which should be passed soon, or at least we expect it to be passed soon, which also speculates or stipulates that these notices, these links, need to be provided in easy to understand language. There needs to be symmetry in choice, so it should be as easy to opt in or out. It should be equally easy. You can't make opting out a convoluted menu and make opting in a one-button click. And then you should also avoid manipulative language, and the notices should match the branding and overall look of your page. So onto the risk assessments and security audits. The CPPA is required to create regulations that will create risk assessments which cover businesses whose processing of consumers' personal information presents a significant risk to consumers' privacy or security. Now, they did not define that law quite yet, but we can assume that it is similar to the GDPR's data protection impact assessments, which are required before processing begins or when there are changes made to processing under the GDPR. There is one key difference in that the risk assessments here are not only self-conducted, they're also submitted to the CPPA for review. And rather than being done before processing and when processing changes, they are an annual requirement for companies that have been identified as having riskful processing. So that would likely, to go out on a limb, mean financial institutions and things like that, as well as businesses that have shown significant risk in the past. The CPRA identifies two factors to be considered when considering this. It's the size and complexity of a business, as well as the nature and scope of the processing activities. Businesses will be required to conduct and submit these on a regular basis, as I said. Beyond that, there are also requirements for reasonable security obligations to take place on any data, any personal data that is stored. Those have not yet been defined. There are also going to be annual cybersecurity audits, which are again self-directed, although they must be thorough and independent. What that means is unknown, but likely would mean hiring a third party or having an auditor on your team. And finally, it's important to note that there are going to be agency audits taking place. So the CPPA does have the right to audit a business, service provider, contractor, or person to ensure compliance with any provision of the CCPA or CPRA. There are three instances where an audit is to be performed. One is to investigate a possible violation. So that might be after a tip or after there's been a data breach. Two is if there is potential significant risk to consumers posed by the business's collection and processing activities. Now that is very subjective, so it gives the CPPA a wide berth to conduct these audits. And three, if the business has a history of non-compliance with the law or any other privacy protection law. So potentially, if you come over under scrutiny in Colorado or in Utah or Connecticut or even in Europe, that gives the CPPA reason to look into your dealings in California and to send an audit your way. So I would imagine that we would see follow-up audits after major enforcement actions in the EU. Sort of a piggybacking effect there. And under the CPPA, there was that heal period that I mentioned earlier. If there was a violation found, you would have 30 days to address that violation. Now that has been lifted as of January 1st, 2023. So if you're under audit, anything that they find that is wrong, they can immediately give you a violation for. So that's, again, just more reason to have everything set for this law and to actually do your due diligence and be prepared. Jason, we have a question here that asks what significant risk is. And I also see another question that says browsers and privacy mode. I assume that has to do with the opt-out preference signals, and that would be, yeah, that is essentially what an opt-out preference signal is. They haven't given technical requirements for that yet, but as of my understanding, that would be like privacy mode or using an ad blocker, things like that. As far as the other question goes, there's a question, what does significant risk mean? We don't have an answer for that. The CPPA has not laid that out yet, but Jason, I think you can speak to maybe where you see significant risk to PII on our clients' systems before we come in and how that can be addressed.
Yeah, absolutely. So let's start with the browser question, then work backward to the significant risk question. So the browser question, when you're talking about respecting signals and stuff like that, right? It could be anything from hey, privacy mode, where if you could detect that this browser is in privacy mode, that you actually just go ahead and proactively suppress your tracking technology, sharing technologies. It's a little bit of it's a little bit convoluted when you think about it, though, because a lot of technology that we leverage when it comes to Chrome, Firefox, whatever, the goal of the browser is to also not let technology running on the page know that it's running in privacy mode, so that way that the technology on the page does not try to circumvent privacy mode. So in the near term, until the technology standards evolve, you probably are still looking at suppressing and performing consumer privacy in the ways that we already know, where it's actually not firing technologies, actually logging that the technology was not fired, actually showing that you received a consent event. Something like the header, again, is probably, this is me speculating, but it's probably the legislature looking at something like DNT from back in the day, if you guys remember, right? It was the old W3C standard that was do not track. It was eventually deprecated by the W3C just because no vendor basically supported it, right? So this is the idea where, hey, as a new W3C standard emerges that can potentially be adopted, maybe we'll start seeing vendors start to support that new standard, and then we'll see a new pattern emerge, right? But this does have implications on all of us, because now we're also have to realize that when consumers start making privacy preferences at that level, you're almost looking at it from a full individual perspective rather than an individual and a brand perspective, right? Right now, when a consumer goes to some airline site and opts in or opts out of certain technologies, that's their relationship with that airline. But potentially what it looks like as far as legislation is hinting at is hey, no, we might be wanting to let them just set global privacy options that no matter where they go on the internet, these privacy options are carried with them and are expected to be respected. Going back to risky behavior and types of processing. So, again, CPRA has not really defined this. We're still waiting for the AG comments. We're still waiting for the CPPA comments, stuff like that. But we could still take hints from other legislations that have been passed, right? So what does that mean? Both, it's going to be the type of data that you process, right? So are you processing records that have health information, financial information, demographic information, right? That are tied to individuals that can be used to make other decisions about them, right? Is it going to be records that potentially come from a financial institution that may also be able to be leveraged to determine credit scores or bank loan qualifications for that end user, or insurance qualifications for a user if it's coming from a health organization? And so this is where you got to be very mindful of the type of data you have, but then also on the other side, how and where you process it. Are you processing in plain text? Have you fuzzed it at all, right? So one common strategy is hey, instead of putting someone's actual take home into their profile, can we bucket them into large enough buckets where they become effectively anonymized in that bucket, right? So this is think of strategies like how Google was looking at that federated learning in computers, regardless of technological challenges with that solution, we still understand the end goal is like, hey, can we create buckets of people that resemble each other enough where no individual is uniquely identifiable, but at the same time, we could still perform effective targeting of advertising or whatever else. So when I see that statement, that's how I interpret it, right? And then obviously, have your traditional cybersecurity measures, right? Is this data encrypted in flight, encrypted in rest? What countries are you processing it? What dominion does the federal authorities of the country that the data is being processed have over your data? For example, right? Like, for anyone that's ever done business in China, you do know that you have to share your private keys with the Chinese government. What implications does that have in terms of the risk you're exposing to your end users? Stuff like that.
Awesome. Yeah. We will look forward to the CPPA's clarification on that. And we did get another question here. Was the employee and B2B exemption removed? I didn't think that was finalized yet. It hasn't been finalized by the CPPA yet. As far as I know, they're on track. They haven't said anything about not removing it, and it was in the initial CPRA draft. So I believe that they are on track there and planning to remove that exemption. And then we're just going to wrap up with a compliance checklist, just the basics, operational impacts to your homepage and your website, as well as your privacy policy. So that would be to include a do not sell or share my personal information link, or the limit my use of SPI link, to include both of those, or one single link that will allow opt-out of both as long as it is clear and conspicuous, to include the new definition of SPI on your privacy policy, as well as provide the required new notices for data retention and minimization, as well as a toll-free number for California residents in that privacy policy as well. And something I did not mention also, when talking about the opt-out, you actually need to give two manners of opt-out. So you can have that link, but you should also have a form fill or the toll-free number as well, so that users of various technical situations can opt out. Identify the sensitive data that may require deletion or redaction, and design a process for finding that data in both structured and unstructured sources efficiently. So this is basic data governance best practices under other laws, like the GDPR. If you are a GDPR compliant organization, you can take your best practices there and apply them to CPRA. They will be of the same caliber and compliance. Review employee, customer, and supplier contracts and update the information of personal information processing if necessary. Implement a process to recognize, verify, and respond to data subject access requests for access, deletion, or correction of inaccurate information. You have 45 days within the receipt of a request to comply with it. Develop data retention and minimization policies for data processing activities, and determine if your business requires regular risk assessments and annual cybersecurity audits. So that would be if you think you're at a high risk, the things Jason was talking about there, or what the CPPA finally identifies as a high risk. The best practice would be to get your cybersecurity up to par, get your data governance practices up to par, and be prepared for an audit. I would recommend having software in place that can give you reporting on your consent situation, as well as do privacy audits. And finally, consider a consent management platform. When we look at the scale of the challenges created by regulations like the CPRA and the GDPR, it's difficult to see it as a human scale problem. Whether manual processes could keep up with this, I think, depends on the resources you're willing to throw at the problem. And in most cases, the best practice would be to have a specialized tool for dealing with regulations like this. So what is next after the CPRA? So it may seem like California is way ahead of the curve on this stuff, but really it's the bellwether in the United States. After the CCPA passed in 2018, we had 6 more privacy laws come onto the books. None of them as strict as the CCPA, but all of them taking elements. Some of them have opt-out. Some of them have do not share. Others are more related to just data governance and security practices. But we now have laws in California, Nevada, Utah, Colorado, Virginia, and Connecticut. So that's 6 laws. And then there are about 28 more states, I think, that have laws in various states of legislation right now. So that's 56% of the states have laws and legislation, and if all those laws were passed, it would cover 85% of the population of the United States. And there are several states that are, on their 4th or 5th try with the laws and are getting pretty close. We have Massachusetts is one that is likely to pass a law within the next year or two. New York State and Washington are others. Massachusetts is one you would particularly want to keep an eye on, because as far as the language of the draft bill goes right now, it would be even more rigid than the CPRA, and up there with the GDPR. It's more or less a GDPR clone. So that is one to keep an eye on. And it's a GDPR clone with a private right of action. So I'm from Massachusetts. It's a litigious state. So you're going to want to keep an eye on that one. We do have a state privacy law tracker on our website. So if you visit insighting.com and go to the resources, you can keep up with all these. I'm frequently updating the status of their legislation, whether they're stuck in committee, whether they have been signed, et cetera. And we do have comparisons of the rights afforded by each law, as well as the obligations set forth for businesses. So with that, I think we're going to move on, and I'm going to let Jason talk a little bit about Insighten and how we solve the issues that the pain points that CPRA brings forth.
Yeah, absolutely. So, as I said before, right, the way Insighten works is very different than a lot of the other consent paradigms that you probably are used to, right? A lot of people have seen the banner approach and just popping something up. And yeah, that's where it starts, but you still need to do more than that, right? You need to be able to understand what is firing on your site, where it's firing, be able to permit or suppress technology running on your site depending on what type of compliance standards you're operating in. So again, if you're operating in Europe, you're going to be having a different configuration, whereas if you're operating in California or potentially even Massachusetts. So again, you need something that's going to be customizable, but also will enforce these regulations in a manner which doesn't impose friction onto your marketing department, right? Because we all know how marketing works, right? We don't just have a single team. We have agencies that we work with. We have outside vendors we work with. We have other ISV partners that we work with, or IT partners that will be rolling out technology on the site. It's kind of an unreasonable ask to say, like, hey, I'm going to continually train all the staff, and I'm going to continually make sure that I have oversight over this. It's like an impossible problem to solve. So for us, where the way our tool was built, it was effectively built to support an environment where we could keep you in compliance from a digital standpoint, but also give you the auditability, the observability, and the controls you need in a centralized location without infringing on your staff or any other partner that you leverage is ability to work. And then, sorry, just a quick aside. One thing that you've probably observed through Jeff's slides here is one of the new, not new, but one of the recurring themes of all these regulations is cybersecurity, right? And what you're starting to see is a convergence of demand of some level of cybersecurity controls that do correlate to privacy rights of the end user, right? So it's not so much that you are tracking or not tracking somebody based off of whether they want you to or not, but it's also going to be something like, hey, did you protect their data? Did you protect their data as it was being collected, as it's being stored, and as it's being used, right? So this is also where Insighten can help give you a lot of mitigation strategies, whereas to even regulate the types of data that your partners can collect, or even prevent unauthorized technologies from running on your site, and then giving you insight as to what was attempted to run, where it was running, why potentially it was running, or what was attempted to be collected, etc. So again, this is a pretty robust tool with a lot of teeth, and is very adaptable to a lot of regulations as they've been emerging.
Yeah, and just before we get to questions, if anyone wants to see a demo of Insighten, if you're not already a customer, you can reach out to us. It's right on the homepage, book a demo, or email us back. We are going to be sharing, someone asked, where can we get a copy of today's materials? We will be sending out the webinar on demand, so you can just reply to that to book a demo as well. If you are an existing customer, I know we do have quite a few on this webinar. You can definitely reach out for a CPR compliance checkup and just make sure that you've got things set up correctly, or if you need additional tools to meet that challenge, we can help you out there. And then just, I know we're over time, but we're just gonna answer a couple questions before we go. Let's see if we got anything new here. The CCPA exempts financial institutions subject to GLBA from requirements. How does this play into the CPRA? So in the exemptions, I did not see financial institutions. I would have to look again right now to be 100% sure in saying this, so I can't offer this as legal advice. That was not in the exemptions as far as I tell. Public institutions are exempted. Nonprofits are exempted. Financial institutions, as far as I saw, are not. That might be something that the CPPA is looking into, and then it could be also something that is impacted by any further federal legislation. I can't say right now off the top of my head that they're exempted. I wouldn't want to give bad advice. As far as other questions go, okay, on topic, would the federal legislation supersede the CPRA? Okay, so this is an interesting question because we do have the American Data Privacy Protection Act and Consumer Online Privacy Rights Act, the ADPBA, in Congress right now. And they do have a preemption clause in the current language that would override some components of the CCPA and the CPRA. Now, whether that law is passed in its current form, whether it makes it through the gridlock of Congress is something yet to be seen. But something that's actually happening tomorrow is the CPPA is going to hold a special meeting to discuss these preemption clauses, and I assume to try to overcome them. So that's yet to be seen whether the ADPPA would override the CPRA. Right now, it's in the language of the federal law that it would. I would imagine that the CPPA is not going to give up without a fight, and that would probably be, an ongoing thing. In which the meantime, however long it takes to get resolved, the best practice would be to be compliant with both laws. Does Insighten help with global privacy control signals, Jason? And that one to you.
Yeah, definitely. So we do have add-ons to our solution where if you need to maintain consent in a more global variety, where, if you have an end user potentially talking to you across multiple channels or in different geos and stuff like that, or on different devices. We have add-on solutions that can help with that. So definitely hit us up about that. Usually those types of configurations are very unique to the business. So it's going to start out as a discussion. We're going to look into how you guys are actually leveraging your current solutions, what your business needs are, and then we could show you like, hey, yeah, this is like what we can do for you as far as how we can support like these global needs. And like, worst case scenario, right? Like, hey, if by some miracle it's a scenario we don't support, right? Like, we're not trying to put on airs here, right? We're going to just point you in the right direction.
All right, I think that pretty much covers the questions we have, and I know we're quite a bit over time, and I want to thank everyone who stuck with us there. It's so much to cover in so little time. It's just like, it's almost overwhelming with these laws. But we are going to have, just to throw it out there, we're going to have a white paper forthcoming as well about CPRA. So any more questions you have, anything more specific, if you want something you can pass around the office, that will be live next week. And we can send that out along with the recording of this, or you can just come to our site and get it in the resources section. If you want to book a demo or get an assessment, you can reach out to us on our website, insighten.com. We've got upcoming, the next webinar will be in, I think, 6 weeks, but you may get communication about that. That would most likely, we're looking at the ADPPA right now, the federal law, to break that down a bit. Thanks everyone for joining us, and have a great day.